Okay, perfect. Well, thank you everybody again for joining today on a start of a holiday weekend to talk about adult guardianship and alternatives here in the state of Arizona. I will quickly clarify that I am an Arizona licensed attorney. But that being said, today's presentation and any information that you may receive is not specific legal advice for you, and we don't have an attorney-client relationship unless or until we formally make that arrangement. So with that, I hope you take away a lot of information from today's conversation that you find valuable, and I encourage you to reach out if you have any questions. A little bit about myself. I see some names that I recognize, but I also see some new names. And so if you don't know me, my name again is Emily, and I grew up in the Midwest. I've been in Arizona for 24 summers. I think that's how we count our time in Arizona, summers we've survived. I attended ASU as well as U of A for law school. I am a proud member of the Special Needs Alliance, a national organization of attorneys who focus their practice on the type of things we're talking about today, as well as the National Academy of Elder Law Attorneys, the State Bar of Arizona, and a few other organizations. My practice is here in Phoenix, but we serve clients throughout the state of Arizona. So with that, we're going to talk a little bit today about a lot of different things, but one of the big things we're covering is young adulthood and what that means in terms of decision making. We're going to talk about decision making in and of itself, and then we're going to think about what pieces we may want to have in place for our loved one or family member as they turn 18. And so we're going to talk about powers of attorney, guardianship, conservatorship, limited guardianship, supported decision making, fees and costs, frequently asked questions. And like I said at the start, please feel free to raise your hand or type a question into chat so we can address anything that I may quickly go over. So a lot of times we're thinking about a young adulthood, and we may put ourselves in the shoes of the people we love and think about what we were like when we were turning 18. And for each of us, it is dramatically different when that date rolls around. But that being said, under the law, it's the same. At that 18th birthday, you suddenly and magically have the power to make a lot of legal decisions. And that may or may not be appropriate for most of us. And so transitioning to adulthood can present some challenges for those individuals who may have a diagnosis or perhaps just a unique set of circumstances that leads to challenges making decisions or making safe decisions. A lot of times, then we also run into situations where if we are a parent or a caregiver or a grandparent, advocating for that person. We've historically, up until 18, made decisions or had conversations with government benefits, care services, healthcare decisions, legal and financial decisions, as well as education. This milestone can present a unique challenge. And when we're trying to think about what's appropriate for us, we want to think about in our family situation or caregiving situation, with this pending or recent 18th birthday, how has that impacted or how might it impact our ability to participate in healthcare? So that means making doctor's appointments, managing medications, picking up prescriptions, talking to health insurance companies, sitting in doctor's appointments, all those things that you may or may not have had the authority, or you may have had the authority to do prior to 18 will suddenly change. We also think about government benefits. So if our loved one is receiving services through Medicaid, so DDD, Altex, Access, if you're planning on or currently receiving Social Security benefits, working with SSI, we have to think about how that's all going to transition. And then finally, education. So while 18 is often seen as a milestone for adults, many of us are still in high school during that time, or perhaps we'll be in high school until 22. Maybe parents are participating in IEP meetings or other advocacy, working with ESA, et cetera. And so we have to think about what is our authority after that 18th birthday. So with that, I always want to kind of start and think about decisions because it's going to be a big part of everything we talk about. There is ideas such as legal capacity, but it's funny because from time to time we will have different opinions on who is assessing that capacity, what it means when somebody wakes up at 5 a.m. and they're blurry eyed, do they have capacity? Is it different for a young adult from day to day? What skill sets do we have? And so, one of the forms that, if you're attending live, you probably received in your inbox from me this week is kind of a checklist of things to start thinking about. And that is because as we walk through today's presentation, we're going to talk about kind of a spectrum of individuals and where they fall in terms of their ability to make decisions. And one of the things that we're going to be looking at or thinking about is what's the right solution for our young adult. And one of the things that we need to know is on most days, what is our level of comfort in terms of their making decisions? And so, some of the things the court or you or an attorney, if you're working one, might be looking at is things like driving a vehicle, voting, executing a contract, applying for government benefits, making education decisions, doctor's appointments, medications, managing finances, making relationship decisions, so getting married, shopping for food, determining daily dress and routine, and making travel decisions. So each of those probably spark for you a thought about your loved one. They may also spark for you a thought about yourself and what that was like for you as a young adult. And each of these, we've got a range. It's not very much black and white. From time to time, there's a lot of gray. Down towards the bottom, you can also see kind of a prompt for you to start thinking about in your unique situation, thinking about vulnerability. So maybe under perfect circumstances, I might make really good decisions about my finances. I might stick to a budget. I might make sure my income's coming in. I might be able to do those things. But what about my vulnerability? What does it take for me to suddenly lose the ability or be influenced by somebody to make a poor decision? What is my level of being able to stand up for myself, advocate for myself, and really consider when I'm making decisions, who might be impacting those decisions? And all of this is going to come into play as we think about all of the different alternatives to guardianship and guardianship itself, what's appropriate for you and your person. So you'll see here that we've kind of got a timeline or a spectrum, if you will, of decision making. And this is my attempt at trying to think about these different topics in terms of being able to put our unique situation onto this line. On one side, we can see complete autonomy. What that means is the day we turn 18, that individual is ready. They are appropriate to go out into the world and be able to make all their own decisions and advocate for themselves. And under the law, that is appropriate. Now, I will say that everybody, when they turn 18 or 80, should have and consider putting into place after that date powers of attorney. So, we'll talk about powers of attorney, healthcare directives, financial powers of attorney, how those work, and how adults, no matter what their skill set is in making decisions, should have powers of attorney in place if they can understand and sign those. We then jump to the other end of the line and we can see guardianship. And this is going to be general guardianship, where we're going to talk about petitioning the court and asking for the removal of somebody's right to make decision and granting that to somebody else. We also can see in between, we've got three other options there. Limited guardianship, so potentially going to court, but not asking for removal of all of those decision-making authorities or rights under the law. And then we also have acronyms, SDM, supported decision making. So both informal and formal supported decision making. And now that that's been in Arizona and legal for about a year, how does that fit into all of this? So my goal today is to kind of walk through each of these different pieces, talk about the pros and cons of those situations, and hopefully it gives you a frame of reference for thinking about your personal and unique situation and determining what's right for you and your family. So if we start with powers of attorney, a power of attorney is a legal document that allows for an individual with capacity to sign and provide an agent, meaning a person or a professional, with the authority to make decisions on that individual's behalf. A lot of us are familiar with healthcare powers of attorney, saying if I can't make or communicate my own healthcare decision, here's who can do that for me. Sometimes we have financial or general powers of attorney. Those can both be effective immediately, meaning once I've signed the power of attorney that grants the authority to the agent I've named, or perhaps springing a power of attorney that says this document or this authority I'm granting is effective at the time a doctor says I'm no longer able to make these decisions. And powers of attorney are really appropriate for a lot of adults who they turn 18, or I kind of joked earlier, 80, and we decide, hey, I'm worried that if in the future I lose the ability to make decisions, I want to make sure I've clearly delineated who should make these decisions for me. So both financial and healthcare decisions. So important to note, we want to make sure powers of attorney are in place in a lot of cases, but there are a lot of situations where an individual will not or cannot understand the nature of the power they're granting. And powers of attorney also do not take away anybody's right to make decisions. What that means is when I sign a healthcare directive or a financial directive, granting that authority to somebody else, that means that they're going to not lose the ability to make decisions themselves. So if I sign a power of attorney that says my sister can make my healthcare decisions, I still get to go into the hospital and make my own healthcare decisions as long as I'm able. If I sign a power of attorney for my brother to be able to make my financial decisions, that doesn't prevent me from being able to go down to the car dealership or sign a check or do anything like that. So powers of attorney are really, really helpful for a lot of individuals, but sometimes they don't help preserve or protect some of the concerns we might have. So we're going to go over kind of quickly the pros and cons of a power of attorney. One of the pros of a power of attorney is it's empowering. It allows us to decide who can make decisions for us. It allows us to kind of weigh our different family and friends and think through who's a good advocate for a healthcare setting, who might be a trustworthy person to make financial decisions. So it's very empowering for the individual to get to decide who their decision makers are. It's generally pretty inexpensive. Arizona, we have free healthcare directives through our Attorney General, so those are available for download. They're easy to obtain. We can log right on. As long as we have ink in our printer, we can print those off. They require either a witness or a notary for healthcare, and both a witness and a notary for financial. Takes about 10-15 minutes to complete the forms, and they're really easy to change. So under the law, if we have capacity, we can revoke these pretty easily. And so if we decide or learn that the person or professionals we've named aren't appropriate, easy to change. So that's a pro in some ways. We also see on the other side of the coin, though, if we're thinking about our loved one putting these powers of attorney in place, one of the cons is also that they're easy to revoke or change. And so if that individual decides that they're mad at you or they have a new best friend or family member that they trust, it's easy for them to change their powers of attorney. The other downside to relying on a power of attorney when we're thinking about our loved one who may have limited or impacted capacity to make decisions is that the presumption still remains that they can make their own decisions. So even though those powers of attorney are in place, again, it doesn't prevent them from being able to go out, get married, go down to the car dealership, sign a loan, and then go make healthcare decisions all on their own. And it presumes that all of those transactions are still valid. There's no presumption or change in presumption in that case. So a lot of things to think about when we're thinking about powers of attorney. And one of the realities is that as we kind of move through all of our different options, they're going to remain as part of the planning process. So if we're jumping now to the other side of that opportunity, and we're thinking about guardianship, I want to kind of jump to the other extreme and talk a little bit about what our guardianship laws look like here in Arizona. So guardianship may be appropriate for an adult who does not have the legal capacity to sign a power of attorney. And a guardianship is a court proceeding that appoints a guardian to make personal, medical, and education decisions for an adult who does not have legal capacity. Guardianship in Arizona is a process in which we are petitioning a court. And so there's a number of different steps. Now, one of the emails you received if you're attending live is a timeline, an outline of the guardianship process. Even that is a shortened version, so it's important that you know all the details. But for today's purposes, generally, this process, which is simplified here, is a number of different steps. So, with pursuing guardianship, one of the first things we're going to want to look at is what type of guardianship do we need? And right now, we're talking about general guardianship, but we'll look at limited guardianship here in a minute. One of the things that the court's going to rely on is a professional health report. And that report is going to be completed by the individual's doctor, psychologist, or psychiatrist. And that report is going to be pretty heavily relied on because it's going to go through and talk about, in that medical professional's opinion, hopefully having a long-standing relationship with their patient, what capacity does that individual have? And so the report of health professional is going to not only document certain diagnoses that are in place, but it's going to talk about medications. It's going to talk about skill sets for activities of daily living and their belief about that individual's ability to make these decisions. That report of health professional is also going to typically look at a couple big specific rights that are potentially at what one of the things the court's going to assess, and that is driving and voting. Those tend to be the two big ones. And so those reports of health professional are really important that they're accurate, that they're detailed, and they're done and completed by somebody who really understands the individual we're going to get guardianship for. That report of health professional is filed with the court along with a series of other pleadings. Pleadings are legal documents, and these documents are going to petition or ask the court to start this guardianship process. Within that petition and ancillary documents, the individuals who are petitioners, the people applying for guardianship, are going to complete a request to start the process. They're going to talk and disclose to the court a number of different pieces of information, whether that individual has ever signed a power of attorney, whether that individual has a trust, whether that individual, who their next closest heirs are, who's entitled to notice. So the start of the guardianship process is submitting these pleadings along with a report of health professional to your county court. The court then, excuse me, will allow you to file these documents, and they're going to set a hearing. Typically, this hearing date, so long as there's not an emergency, is going to be set about 45 to 75 days out. And that's because not only is the court busy, but most importantly, there's a number of steps that need to be completed to make sure that due process is handled between the time the pleadings are filed, the date is set, and the hearing date itself. So with that, in a guardianship procedure in Arizona, there's a number of steps that need to be taken. So once the hearing date is known, notice must be given to certain individuals. It's different for every situation, but commonly notice is required for adult children, both parents, sometimes siblings, and specifically the individual subject to the guardianship. And sometimes that notice must be done through personal service, meaning a process server, or the sheriff delivering a copy of the notice of hearing and a copy of the petition. What the court and the law wants to assure is that certain people who are entitled to notice are aware of the upcoming hearing, are aware that they can attend, and are aware that they can object if appropriate. After notice, there's also going to be the appointment of a court-appointed attorney. So the individual whose rights are being considered under the guardianship process is required to have an attorney. And this attorney is appointed by the court. And in Arizona, there are typically a list. In some counties, the list is longer than others, but a list of attorneys who are available to take on this type of work. That attorney's job is to represent the interests of the individual who's subject to the guardianship before the court, and they will be meeting with that individual prior to the hearing, and a lot of times will represent that individual at the hearing itself. Now, if the individual is unable to communicate about their preferences or their position as it relates to the guardianship, the attorney will still report to the court their interactions and make sure that their certain rights have been met. There is also going to be a court investigator. So the court investigator's role is to meet with the individuals of the hearing, so the petitioners, sometimes the attorneys, sometimes the ward, and to prepare a report for the court to review. The judge is not personally going to come visit your home or be able to have the time or capacity to understand these things. So they're going to rely really heavily on both the report of health professional, but also the court investigator's report, and finally the report given by the court appointed counsel. Now, all of these things are intended to protect the individual subject to the guardianship. And so the law is really clear that their rights are to be protected. And so a lot of times, some family members will say it's very clear that guardianship is appropriate. My child or grandchild absolutely needs a guardianship. Why do we have to do all these things? And again, under the law, these are the rights that they have. And so these steps must be followed in every situation. Now, at the end of the day, you're going to attend a hearing. I will say if you're in Maricopa County, the process is still largely virtual, meaning that you will be able to attend your hearing virtually through Microsoft Teams. In different counties throughout the state, there are usually always virtual options available. In some cases, you can actually attend in person, but you'll want to make sure you understand how that hearing's been set and what your rights are for attending it. If all of the steps have been taken prior to the hearing, then that initial hearing that is scheduled can sometimes be the only hearing that you actually have to attend. That hearing itself can be somewhere between 15 to 30 minutes long. The judge has a number of things that they have to review and go over with the parties. Depending on the judge or the commissioner, there's going to be a series of questions asked of the petitioners and the ward and the attorneys. It's unique from case to case and from judge to judge, the exact process, but largely it's not something to be worried about or concerned about so long as you've followed all the steps. At the conclusion of the hearing, this first hearing, if there are no objections, then commonly the court will issue an order, meaning they'll make findings about whether the guardianship is appropriate, and in a lot of instances, actually appoint a guardian. Now, if anybody's objecting to the guardianship, then typically there is not an outcome or a finding or ruling made at this hearing, and instead the judge is going to set forth a schedule for hearing any conflict or objections. If the judge does sign the orders, then after the orders have been signed, letters of guardianship must be issued by the court. These letters of guardianship are your proof as the parents or grandparents that you are now guardians. And so even though the individual is an adult, when you go to the doctor's office, when you talk to DDD, when you're attending an education hearing, this is your proof that you have the right to step in and make the decisions according to the guardianship in those different areas. So again, that's a very shortened and simplified procedure for the guardianship, but hopefully at a high level kind of outlines those different pieces. Now, some of the pros of pursuing guardianship is that the letters of guardianship are well recognized by doctors, DDD, schools, etc. And so this guardianship is the proof that you now have the ability to participate and make decisions. The guardianship reporting in Arizona is relatively easy, meaning annually you have to fill out a form. That form does need to have with it a report of the doctor, but it's not the same report as you filed in the beginning. It can be a shortened version, it can just be notes. And one of the best pros is that it changes the legal presumption regarding the individual's actions. So in that case, what that means is even though if there is a general guardianship in place, that individual may still literally walk down to the car dealership or walk to get a marriage license. The marriage is voidable. The contract is voidable because there is that legal finding that they lack the ability to make decisions, that they are an incapacitated adult, and that somebody else has the authority to do that. Some of the downsides to general guardianship is that in a lot of cases, or in some cases, that can feel overly restrictive for removing an individual's all of their rights to make decisions. The other downside can be that this process can feel or be expensive and stressful. That's because for a lot of us, we have the benefit of not having to go to court for many things. We may not talk to or work with attorneys on a regular basis. There's a lot of detail and process steps that are unique, and it's the first time you're doing it, so it can feel very stressful in that case. I want to make quick mention of conservatorship. I know we just talked a lot about guardianship, but conservatorship is also a very similar process under the courts here in Arizona. Now, from state to state, the terminology changes, but in Arizona, a guardianship is going to be the legal procedure we just went through to allow for an individual to make healthcare and personal decisions about the individual. Conservatorship is the same process or very similar process for financial decision making. Financial decision making conservatorship may be appropriate for an individual who lacks the capacity to do that for themselves. However, the reason I'm not focusing a lot on it today is today we're talking about guardianship for young adults. So we're talking about individuals who commonly do not have significant financial resources or significant income. And in fact, if their only income is going to be their Social Security and their only assets are managed perhaps by a special needs trust, then in fact, conservatorship is often not warranted for a young adult. So any individual who is on or receiving services through Altex or SSI is commonly not going to need a conservatorship. So one of those things I'll kind of put an asterisk by, and it's something that you should talk about with your attorney or look through the paperwork if you're filing on your own when you're applying, but it's not common to need a conservatorship for a young adult who's receiving SSI or Altex or has very limited financial means. And often SSI, for example, appoints a representative payee, and Altex will have a authorized representative as well. So conservatorship is a very unique process, but in Arizona, it's the financial process and it's not commonly needed for young adults who don't have their own financial resources. So with the guardianship, we've focused or talked about how one of the negatives can be for some individuals that it's overly restrictive. And so with that, Arizona has what's called limited guardianship. And that means we're going through the very same or similar process that we just discussed before, but we're carving out certain rights that are not going to be taken away by the guardianship. Commonly in Arizona, those big ones are voting and driving. Sometimes they're things like marriage. Sometimes they're very specific things like we need a limited guardianship just for purposes of X, Y, and Z. So guardianship is one of the things that if we're pursuing that, we really want to spend a lot of time on that decision-making questionnaire we were looking at earlier, because it's going to be very unique for every situation. I think one of the pros of the limited guardianship is that it is more empowering. It is an opportunity to say that this young adult perhaps still struggles with the ability to make or understand contracts and financial management and government benefits. However, with either the right supports or appropriate mechanisms in place, they can still exercise their right to vote. They can still review and consider candidates and issues and have the capacity to do things like voting. Some individuals have the ability to drive so that they are already either have a driver's license or will soon be getting one. We don't want to take away automatically their right to drive. Now, these issues are really going to need to be addressed by the medical professional as well as the petitioners so that by the time you get to court, you have a lot of evidence. The voting issue is something that the Arizona Constitution addresses. And so judges are going to want to see a lot of information that says, here's why it's appropriate to take away some of this individual's rights to make decisions, but here's why it's appropriate to maintain these other decisions. Recently, I just had a judge who was thrilled that we had not only the voting addendum completed by the doctor, but also by this young adult's civics professor. So their government teacher who saw this young adult, day to day for semesters or years, really was able to outline or express why they believe this individual did have the capacity to vote. So things like that, gathering evidence, not only from the parents or petitioners and saying this is why this is important and this is why it's appropriate, but a lot of times we also need to hear from the individual who's subject to the guardianship. If they are attending the hearing, we want to make sure that they can speak up and say, yes, I want to vote. And yes, here's how I'm going to be able to learn and investigate the issues I'm concerned about and express my own individual opinion. Now, a lot of times the judges will also joke, although they're not joking, make it very clear to the parents or the petitioners that just because we're maintaining a right to vote does not give you any ability to influence or impact how that or who that person might vote for. So the pros of the limited guardianship are it's empowering in that way. It's the least restrictive option that's appropriate under the case. It grants authority, meaning in a limited guardianship, we are still getting those letters of guardianship. The letters of guardianship, that proof is still in place. Now, the letters are going to say something different. It's going to delineate what powers are in place, but it's appropriate and it gives you that report that the medical authority and agencies are going to acknowledge and recognize. And it also means that we have an open court case. And so, in the event something fails or it's no longer appropriate to have some of those powers that we've allowed, we have a way to go back to court and to ask the court to address those issues. Now, the downside is that this process still requires all those due process protections. I don't actually think that's a downside. I think that's really appropriate and great, but it does require that we're still going to have court appointed attorneys, we're still going to have court investigators, and all of that information. And then the same fees and costs are going to be in place in terms of moving through the process, and we have the same annual reporting requirements. So limited guardianship you might see is something that's going to be appropriate. Now, we talked about powers of attorney for every adult who can, and we talked about guardianship and limited guardianship. But in between, we have now in Arizona a process called supported decision making. It was passed just about a year ago, so time flies, and then put into effect in the fall. It's something that different states have had, and different states have had different levels of success, and other countries too. But if we think about this, at the end of the day, we're thinking about an individual's rights to make decisions and their ability to make decisions. So supported decision making is intended to be something that kind of fits in that gap where perhaps making 100% of their own decisions individually is not appropriate, but also taking away their rights to make decisions is also not appropriate. And so supported decision making is an alternative to guardianship. One of the things that's really important to think about is that supported decision making is a written or witnessed agreement. It can also be an informal arrangement. So we have both formal and informal. If I think about my life and my decisions I make every day, I have a very informal supported decision-making agreement in place. I know that when I'm going to need to make a decision about my household or some things that might impact my family, I'm going to consult with certain individuals in my life. I'm going to ask their opinions. I'm going to take into consideration the information they might be able to provide. That's an informal supported decision-making agreement. Now, I think with that, it's really important because it's part of person-centered planning. It's really catering to that individual's unique circumstances, and it's definitely a less restricted alternative to guardianship. Under the law, so with the new supported decision-making agreement, this is that formal written contract, and it allows an individual's supporters, so friends, families, social workers, things like that, the ability to assist the adult in understanding the options, responsibilities, and consequences of the adult's life decisions. So you'll note we're not taking away anybody's rights to make decisions. The individual, in fact, has to make their own decisions, but we're formalizing the arrangement in which who else can help them make these decisions in understanding the options, responsibilities, and consequences. This agreement can allow for others or supporters to assist the adult in accessing, collecting, and obtaining information that's relevant, including medical, psychological, financial, education, and treatment records. It allows in understanding and it allows in communicating. Under the law, though, supporters cannot sign legal documents on behalf of an adult or bind the adult in a legal agreement. They cannot, of course, intimidate or deceive the adult to make sure that this agreement's in place. They can't receive compensation for being a supporter. And in the event the agreement is terminated or if guardianship is later pursued, then that supported decision-making agreement is no longer valid. There are now under the law, because this passed about a year ago, consequences to violating this supported decision-making. So criminal prosecution and civil penalties, good things to have. At the end of the day, though, supported decision-making is not somebody else deciding what's in an individual's best interest. It's not somebody else substituting their own judgment or decisions, and it's not somebody else making your decisions. So it's really important that there is a pretty strong line there between the guardianship and the supported decision-making agreement, whether it's formal or informal. The pros are obviously it's very empowering, and it allows for that individual to really learn how and get experience in making decisions that impact their life now that they're an adult. It allows for flexibility and autonomy, and of course, increased independence. The cons or downside is that the law is newly effective. And so there are still kind of some uncertainties in terms of when you go to the doctor. This may be the doctor's first time seeing a supported decision making agreement. So they may not know how to respond or use it. We hope and may have to do some education in supporting the contract, but it is something that is being implemented at different levels. And so I think over time that will improve. And again, it doesn't prevent the individual from contracting. And so, whoops, a lot of times we're going to be thinking about with both formal and informal supported decision making, while we're not taking away any of those rights or changing the presumption, it might be really, really helpful to have powers of attorney in play with supported decision making. So when somebody wants to sign a supported decision-making agreement saying that here's my supporters, here's what they can do, here's the information they can have, here's how they can help me make these decisions, they also are an adult. And so it's still a good idea for them to have powers of attorney because they may lose the ability to make decisions in the future. And we want to make sure that the right individuals have the ability to do that. And so it's usually a combination of supported decision-making and powers of attorney if we're not pursuing a guardianship or a limited guardianship. So frequently asked questions, and with that, I'll remind everybody that's on here live, you are welcome to, through the chat or Q&A, raise your hand or ask a question and I'll get to you. But here's a few questions that come up quite a bit and I kind of want to go over. So first of all, that notice requirement. So both in the guardianship, conservatorship, and limited guardianship, who has to be given notice? The alleged incapacitated adult, right? So the individual who's subject to the guardianship or conservatorship, their spouse, although with young adulthood, maybe they're not married yet, their parents. So what does that mean? That means even if father is on the birth certificate but has been not involved in their life, we still have to locate them and give them notice. Parents, if maybe a grandparent has been an informal guardian for a long period of time because parents are not around, we still have to locate and notify the actual parents. So that doesn't apply when parental rights have been severed and or adoption's been in place, but it is something to be really careful about. And it's one of the things you really need to think through if you've got a unique situation there, or what I like to call a modern family situation. The notice is also required to be given to any person who has the care and custody of the alleged incapacitated adult in play. And then if none of the above apply to this situation, at least one other adult relative, if we can locate them. What does guardianship cost? So I mentioned that fees and cost of guardianship can seem like or can be a lot. So many people are hesitant to do it for this way. In Arizona, the two big fees are the Arizona filing fee, which is $279, as well as a court investigator fee, so $400. Those two fees and costs, there is available in every county an option to complete a request for a deferral or waiver of those fees. So I'd encourage you to review that. If your financial circumstances are limited, then you can ask the court to defer or waive those fees and costs. The court-appointed attorney, meaning the attorney appointed for the individual subject to the guardianship, their fees will be paid by the individual in their estate unless there's been a finding of indigency, meaning that our young adult can't pay these fees. So again, in the event if our loved one's on SSI or will be shortly on SSI or all tax, then commonly because they're required to have less than $2,000, those court-appointed attorney's fees will be waived or paid by the county because that person is found to be indigent. And then certified letters, or the letters that are in place for the copies of the letters, is about $30 a copy. In terms of you as petitioner, if you are doing this on your own, it's typically free in the sense that you don't have to pay to get the forms. Each county has forms available. Some counties are easier than others to locate, but I would encourage you to look into those. Hiring an attorney to represent you or a parent advocate or a paralegal are all options. Obviously, I'm an attorney and our firm does represent petitioners or families going before the court. We charge on a flat fee, meaning if it's a fixed cost that's agreed upon in advance, and payment plans are available, but every attorney will handle things differently and it may depend in large part about some different factors that are considered. And so, uniqueness of your case, you just want to make sure that if you are retaining or hiring somebody. Now, document preparers or family advocates a lot of times can help with filing the paperwork, but typically they do not appear before the court with you, whereas an attorney does. So just something to consider as you're looking into what works best for you. Do you need an attorney? I would just say, not always, but some of the factors to consider are your comfort level with pursuing this court procedure. So some people are really good at paperwork and being organized and can follow the instructions. They've reviewed the documents and they feel really good. Availability for time. Many of you have a lot on your plates between work and family and other stressors. So just your availability there. Sometimes working with a professional can be helpful to take some of that off your shoulders. And then, of course, the situation at hand. Are we pursuing general guardianship? Well, if that's appropriate in your case, then that's typically going to be an easier path forward than limited, because as we talked about, voting, driving, that's going to require additional evidence. It may not fit the forms that are available by the court, that type of thing. And then, of course, who is asking? If we anticipate that parents are divorced and they may not agree, or if one of the parents is absent and we need to locate them to pursue notice, things like that can add extra layers of complexity that it makes it more appropriate to have an attorney at play. If you are doing it on your own or representing yourself before the court, the tips I wanted to mention are just, of course, make sure you locate your county's forms. So Maricopa County through the Maricopa County Superior Court. Same for most other counties in the state. And feel free to let me know if you have trouble locating them and I might be able to get you in the right direction. My recommendation is, while some counties will break the forms or packets into different stages of the guardianship, I encourage you to read all the way through the process so that not only are we filing the right paperwork to start, but we're also making sure that we've got the other information about notice and service and court appointed counsel and all of those different steps lined up. I always recommend you're kind to court staff and court appointed counsel. When I say court staff, I also mean court investigators. Everything that goes on gets reported in the court investigators report, and a lot of these individuals may have a lot of files on their desk, but they're doing their best to assist. So obviously being kind and courteous to them can go a long way. And a lot of times if you're representing yourself, they can do a lot to help you out and make sure things are going to go smoothly. And then of course, be organized, make sure you keep copies of everything, make sure you've got all of your things stamped and signed, sealed, delivered. so that you can reference those things. I haven't seen anybody ask any questions yet, so I will give you a few more minutes to kind of raise your hand or reach out through the chat. I see one person here has a question now, so hold on a second. Okay, Kathy and Dale, you're on mute, but there we go. You have a question?
Yes, my first comment was when we tried to chat, it said that you had not enabled it.
Oh,
So,
well,
but
go ahead.
but my question was, for the supported decision making, you said that the person cannot be compensated, which I understand. But could the caregiver, the support person, still be paid for habilitation or attendant care or anything like that through DDD?
That's a great question. And I think that is one of the things we're trying to work out based on the laws that were first passed, as well as what is going to happen moving forward. But yes, my understanding is that specifically under the law means you can't be compensated for your services as a supporter. So not only would you potentially be compensated as for respite or HAB or whatever the services you're getting through Altex, but also sometimes parents may be getting paid rent out of SSI funds and things like that. So I don't think that those things would cause problems, but it is something that under the law isn't explicitly clear, but my interpretation of it is that your inability to get paid is your inability to get paid as a supporter. So I hope that helps. Does that make sense?
Yes,
And
thank you.
yeah, any other questions? I'm going to put you on mute. If you have another question, let me know. And then I'm going to move to Peggy. Did you have a question? You need to unmute yourself if you do.
Okay.
There we go. I can hear you now.
Okay. I just wanted to let you know that I did try to put something in chat, and there's a message indicating that the host has disabled attendee chat.
Yeah,
So,
Kathy just mentioned that. I apologize. You're learning my tech friendliness, and I guess it's not that great.
okay. Well, first of all, thank you for doing this webinar. It's so educational for me. I actually was attending for information as to how guardianship applied for senior citizens, but I'm guessing a lot of this would still be applicable.
Absolutely, it is. And a lot of times, so for senior citizens in the guardianship and conservatorship process, in fact, when you're an adult under the law, you're an adult. So you'll find that the trainings that are required, for example, are the same whether you're 18 or 108. And so you're right, the forms for the court forms, the things we went over are true. I think one of the biggest differences is that a lot of times individuals who are elderly do have the need for a conservatorship. So there are usually sources of income or assets that also need to be managed. And so commonly you're looking at a combined guardianship and conservatorship. And the other piece is that if you're elderly, then perhaps they at some point during their life have signed powers of attorney or established other legal documents. And so you just really want to be clear what that looks like. So absolutely. But were there any specific questions you had for me on that?
Well, the one that I was thinking of in specific was determining the capacity to make decisions. Um, you
It's,
know,
and that
for a senior citizen, we ran into trouble. I used to be an investigator with Adult Protective Services, and we ran into trouble with the judge not accepting determinations from anybody, but it was a neuropsychiatrist. Like, it couldn't be a psychologist, it couldn't be just a regular social worker or health care worker. He was very specific about the determination of capacity. And I was wondering if you've ever, I know all judges can be different, but have you
yeah.
run into any issues on that?
So where I've seen that come up is when there's a contest. So if somebody perhaps has their physician complete the report of health professional, but then that individual or a family member is disagreeing. And it usually depends on, or is more common to see that neuropsych report required in a case where it is a kind of a unique type of dementia or something like that. So it's not common that they would require that level, and especially not for young adults, but I do know that, if there's a contest, then a lot of times there can be further required independent medical evaluations. And in those cases, it can require a certain type of doctor, but it's not always required, is I guess a fair way to say that.
Okay, well, thank
Yeah.
you for that. Appreciate it.
Yeah, no problem. Thank you for the question. I'm going to
Mhm.
go ahead and put you on mute, but raise your hand again if you have another one. Okay, then Nanette, I saw that you raised your hand. I'm going to unmute yourself. There we go.
Am I good now?
You're good now. Did you have a question?
Yes. I have a guardianship over a young man who is 17. He will be 18 next May. I took guardianship over him through the foster care system. Father's rights were severed.
Mm-hmm.
Mother's rights were not severed, even though the judge, he just determined that the children had a relationship with the mom, but she was not able to take care of them. So he granted us guardianship. And she's talking about when this young man reaches 18, he's going to come home. And I don't think she's ready. There's mental health issues involved.
Yeah.
Is there a way that we could still petition the court?
Yeah, absolutely. So with adult guardianship, even though you had guardianship of the minor, it'll need to be pursued. Now you can start adult guardianship 6 months before the 18th birthday. So you'll want to start, so there's not a lapse there. But you absolutely can still petition. Now, what the court's going to consider and require is that notice. But there's also a hierarchy of who has priority. And what you'll want to be clear on is you have a certain level of priority because you are currently acting as the guardian, and mom also has a certain level of priority. And so you'll want to, of course, petition, make it clear that you have been in this position of the guardian for how long and the information you have in the background. But potentially, if mom really pursues objecting to your appointment or something like that, then you will need to provide evidence about why it's not appropriate for her to be. Now, they'll also take into consideration your young adult's opinion or position if they're able to communicate one. So it is something that I think it'd be helpful for you to start early, right? So right after that 17 and a half, and get in front of the court and see what her position is. But a lot of times the court's definitely going to consider what transpired, and can and could consider the evidence that was also in the family law court or the juvenile court when the guardianship was undertaken. So short answer is she still has rights to be notified and to give her position, but it sounds like based on what you're describing, if she's not yet appropriate, then that will be something the court will take into consideration when determining who should be the adult guardian.
Okay. And I guess my second question would be, would we present this to the same judge who granted the guardianship, or would it have to go through? Actually, that was in a different city
Okay.
than what we're in. So, and we live in the Phoenix area. So would it
Yeah,
have to
so
come from Phoenix or from the city where he was originally taken away from?
no, so it's actually going to be entirely in a different court system. So even if you were in the same place, but especially because you're not, you're going to file the adult guardianship under the umbrella of the probate court, whereas the
Okay.
guardianship was juvenile court.
Okay.
Yeah, so you'll start kind of clean, but one of the questions that's prompted in the petition is, have there been any determinations? And so you can provide information about the minor guardianship in there, and they should be able to get access. The judges should be able to get access, judges and court investigators.
Okay. I appreciate it. Thank you.
Yeah, no problem. Thank you. I'm gonna mute you, and then I have another question from Jennifer. Jennifer, if you want to unmute yourself, you can ask that question.
Hi, yeah, it's just about the health professionals report. Is this something that his primary care can fill out, or is this a court-appointed health professional?
It is something his primary care can fill out. The only heads up I will give is in some cases, primary care can be a nurse practitioner. And if the nurse practitioner is not technically a MD or DO or whatever the other acronyms are, their supervising doctor does need to sign off on it. But usually their primary care, especially if they've been seeing them for months or years, is a great person to complete that.
And do I take this form that you included as an attachment to them, or they have their own forms that they fill out?
If you're here in Maricopa County, you'll use the form I attached. If you're in a different county, you would want to find that county's form, but they're all very similar. But they're not going to do their own form. Yeah. Yeah.
Okay, thank you.
Yeah. Okay. And then it turns out, I think, I meant to say that you could ask the questions through the Q&A, because some people were successfully able to do that rather than the chat. But under the Q&A, somebody asked what financial responsibility falls on the parents if someone wants to sue the child in limited and full guardianship. And so in that guardianship, again, anytime there's a lawsuit, they're going to try to extend liability to an individual who may be responsible. And so just like with minor children, there is concepts like negligence and gross negligence. And so if the actions of the guardian led to whatever caused the lawsuit, there is some potential. But of course, if you undertake appropriate planning and aren't doing things like encouraging somebody under guardianship who doesn't have a driver's license to drive, then your risk is not greatly extended. And so the financial responsibility does not extend, meaning that just because somebody becomes somebody's guardian when they're an adult, they no longer have the same financial responsibility that a parent does, but something to look at and think about. And if you have specific concerns, you should talk to an attorney about it. But typically the liability extension is based on their violation of the laws or risk there. And then somebody asked that whether this webinar would be offered again. It's definitely going to be offered again. Keep an eye out on that. I do it usually like once a quarter, a couple times a year, but also I have been recording it. And so I will go ahead and share the recording once it's up on YouTube in a couple days or a week or so with those who registered for it. So keep an eye out for that and you can watch the beginning of it. Okay. I think that kind of goes through all the questions that currently people had. But if there's anything else, I will be following up with everybody. So keep an eye on your email and let me know if you have questions. And of course, if you wanted to meet with me, I will also provide in that follow-up email a link to schedule a consultation. But I hope you found some value in today. And I hope that if you have questions or need anything, you'll let me know. And we'll talk again soon and have a great holiday weekend. Thank you, everybody.